Thank you for joining us. Today is December 1st. It's the first Tuesday of the month. I apologize for being a little bit late. We were having some technical difficulties, but we are going to go ahead and get started right away. So to give you guys an idea, my law firm, JonesKertz, hosts this webinar every single month on the first Tuesday of every month. We do it for a couple of reasons. Number one is really education. From what we can tell, we see a lot of brand new startups, brand new entrepreneurs that are making a lot of mistakes that could really be fixed early on and for the better. Our goal with all of this is, to provide you with, more of the fundamentals and some of the not so fundamental stuff that you'll pick up along the way. And as far as what we do, we are business lawyers. I don't really practice litigation. We really do serve four major categories of people: entrepreneurs, startups, really rapidly growing companies and high growth startups, and investors. So we do the buy and sell side. We do labor and employment law for startups. We do practically everything a startup or a business would need, right? So, and to give you an idea, we're pretty open to questions. So, as we're moving along with this, please feel free to ask questions. Please feel free to pick our brain by sending us an email. If you're based in Oklahoma or want to email Matt because he's got some experience in the area you're interested in, feel free to email him at mjones@vergelaw.com. And then if you have any questions for me, feel free to email me at kyle@joneskertz.com. I'm pretty responsive with that and try to make sure that I'm answering your questions if possible. To give you an idea, Matt controls our Oklahoma office. He manages our Oklahoma region. I do our Texas regional stuff, and we do serve companies that are from different parts of the U.S., but mainly Texas and Oklahoma. Though it appears we may be expanding further here in the near future. Nothing definite on that yet, but it looks like we may be going south or southwest or southeast pretty soon. So to give you an idea, here's really the mission for why we do this. Like I said, it's education, but the idea is better education, better foundation leads to more successful startups. The idea with this is we want to sort of reduce the failure rate for startups and entrepreneurs in general. We want to make sure that you understand more about what you need to do and when, right? So, we've done this series since April of this year, and we've gone through several different topics. You can go back into the library and see some of that stuff where we address business formation and structuring. I address labor and employment law. I address venture deals and the different types of deals you can do. I address advisor agreements. I address, you name it. And the idea is we try to make this a little bit different, but I do actually circle back with some material just to make sure, some of the newer people that are coming into the presentation for the first time are actually picking up on some of the basics. So without further ado, we're going to go ahead and get right into it. So actually, the first topic here and the third topic are holdovers from the previous ones. I didn't have time to change it before this morning, but we are going to go through a legal update, and then we're going to go through mainly trademarks. So, and the reason for this is trademarks, the trademark law is not necessarily going to change in 2021, but there are going to be filing fee changes. So we've been telling a lot of people, if you've been on the fence about filing a trademark, it might make sense for you to just go ahead and decide to do that in December instead of waiting until the next year. And this is not a hard sell on this stuff. It's more a matter of the costs are really going up. So to give you an idea, look at this top right here where it says new standard trademark application, $350 per class, up from $275. That's a significant increase. The USPTO is, from what it appears, like the decisions that were made by, I guess, the executive branch of the government when it comes to reduction in taxes, as well as the overall spending in the year 2020 has led to an increase in these fees. A $75 increase is pretty high. Keep in mind, like when you look at when you look at this in the grand scheme of things, it's going up 20%. I mean, or 25% almost. And so we really do. I mean, if you have been on the fence about this, it might make sense for you to just go ahead and pull the trigger on getting a trademark done, because quite frankly, I mean, it's going to cost you a lot more going forward, especially if you have multiple classes. I mean, you're paying an additional $75 per class. And we're going to get into what the different classes are and how those are sort of differentiated. But yeah, you go into, so there are two different types of applications, the standard and the plus. I mean, plus you're going to be, I believe plus is a little bit faster. The standard trademark application is going to cost you a little bit more because you're going a little more in depth, and it's going to take the attorney a little bit longer to review. So letter of protest is new. Apparently, you can now send those through the USPTO. Amendments to goods services after renewal has been filed. So that's basically, I mean, you're basically changing the description of the goods or services. And that's actually pretty helpful because, I mean, as time goes on, your use of a trademark changes, right? And I think the USPTO is finally acknowledging that. And so as far as this goes, I mean, some of this stuff is really going to get expensive. I mean, the petition to cancel, $600 per class, up from $400. I mean, not a lot of people really do petitions to cancel, I would say. I mean, but that is a pretty big increase. That's 50% per class. Notice of opposition, $600 per class. I mean, that's pretty expensive. I mean, but I think that's probably reflective of the amount of time that it takes these attorneys to get through these applications. If you need any more information on that, I can send you a link with a further breakdown of this, as well as a link to the press release for this sort of thing. So, but some other news, though. I mean, keep in mind we are at the end of the year. So, I mean, as far as the end of the year goes, I mean, you're going to be sort of closing out your books for 2020 if you have a business, and you're going to be filing annual reports with state and federal governments. I mean, if you have an LLC, you're going to be filing, I believe it's Form 1065 to file for your taxes. You're going to be filing corporate taxes if you have a corporation, no matter what state you're in, and you're going to be doing that with the federal government. But as far as deadlines go for the major states that we serve, so in Texas, May 15th is the deadline for filing your no tax due report or your annual report if you do have tax due. And keep in mind, a lot of people say, yeah, Texas doesn't have state income tax for businesses. That's technically not true. It's just really, you just have to make a ton of money in order to pay tax. And so if you're making more than $1.2 million per year in revenue, you're going to need to probably pay tax. As well as you need to pay franchise tax if you're one of the listed categories. So if you're in the insurance industry or some other industry that is subject to state income tax, you'll have to pay that. And the state income tax in Texas is 3.75%. I believe every year the threshold goes up for the amount of money you have to earn in order to be subject to the state income tax. I mean, $1.2 million is a lot of money. So, I mean, most of our clients, I mean, since we serve early stage startups, I mean, unless they're really doing a lot of business early on, I mean, are not going to be subject to these rules. But keep in mind, if you're a Delaware corporation and you are registered to do business in Texas and you are making more than $1.2 million a year, you do need to file a tax due report. Yes. I mean, a lot of people, they go, oh, like, do I need to file taxes if I'm a Delaware corporation or a Delaware LLC? Technically, yes. It's where the business operates as a headquarters. And I mean, and that's regardless of whether you've registered it or not. So if you haven't registered your Delaware corporation and you are headquartering it from Texas, for example, you have a startup based in Austin, you probably need to go do that. So as far as Delaware goes, for LLCs, the franchise tax, that'll be due June 1st. Corporations is a little bit earlier. You're going to be filing that March 1st. And I mean, if you need any other information on, hey, how do I calculate in like a franchise tax, et cetera, I can send you a couple links. So just drop me a line and I'll reply to that with some information for you to go find that on your own. So aside from that, before we move on to trademarks, a couple of other things, just housekeeping wise for businesses, like if you are like, this is like the 30-day push for a lot of businesses. I know the holidays are coming up, but a lot of businesses are trying to make the most out of the rest of the year by making as much money as they possibly can, but also talking to their accountants, talking to their lawyers, talking to the other professionals that are in their corner about reducing tax, what money they can spend, I mean, et cetera. And keep in mind, like, I mean, whenever you're paying legal fees, those legal fees are tax deductible. So, I mean, you can charge it against, you can bill it against your business and take the tax deduction. Sorry. And so, I mean, I would say talk to your accountant and see, okay, if you've had a great year, I mean, where can you spend money? I mean, what equipment can you buy? What things can you do to potentially make potentially make your tax liability or reduce your tax liability reduce your tax liability. Sorry. So without further ado, we're going to go into trademarks. So I'll tell you, like, I mean, to give you a general sense of why we're talking about this, I mean, shortly after we form most businesses for our startup clients, I mean, sometime around the 6-month mark or the 9-month mark, I would say, we end up getting questions about trademarks. And I mean, probably one of the more common questions is do I need a trademark just to have a name or a logo? Like, or can I figure out the name of my business first? And I'll answer that question right now. Technically, like, the name you pick for the business does not have to be a trademarkable name itself. So, I mean, sometimes we're just naming businesses after the people themselves. So, for instance, I could name a business Kyle Kertz LLC. There's no problem with that, though. From a brand standpoint, it's probably not the smartest move because, I mean, trademarking my first and last name is not really feasible. But to give you an idea, like, a lot of people, they are deciding, I mean, what the brand wants to be and wanting to use that as their corporation name. And so, I mean, in certain cases, when you're evaluating that, it's not a chicken and the egg situation. You can figure out what name you want to use first without needing to know whether or not it's trademarkable, right? That said, later on, I mean, you may find out, you know, somebody else is really using this name and actually it's creating some confusion. And we'll get to that here in a little bit because confusion is a big aspect of trademark law. It's one of the reasons why trademarks exist, is to prevent confusion among brands, among logos, among trade names, things like that. So, I mean, if you have any questions throughout this, please feel free to ask. We do this stuff all the time. And I mean, it's a fairly straightforward set of law, though there are some key issues and some other stuff that does make it a little more complex sometimes. So, do we have any questions yet? Okay, great. So we're going to go ahead and get started with this. So why obtain a US trademark? So in reality, I mean, when we look at starting a business, I mean, especially from a legal standpoint for our clients, like, one of the things we're looking at is, I mean, we started with the intent that we are going to exit it at some point, or the client is going to exit it at some point, meaning you are going to sell your business or the assets of the business are going to be acquired, and we are going to terminate that business's existence after the acquisition. And when we talk about assets, we're talking about both tangible property and intangible property. So tangible property being the computers, the desks, the chairs, I mean, all the stuff you own down to the pens and paper, right? But we're also talking about, I mean, intangible property, meaning, I mean, the logos, the trademarks, whether they're registered or not. And that's really where this comes into use. So, I mean, some brands are trademark heavy brands. And I'll talk about this in a minute, but like, I mean, you really are protecting your business intellectual property. you're protecting the name that you're using and also just the brand itself. And we're talking a combination of words, logos, symbols, designs, trade dress, which can be product packaging, product shape. I mean, the feel and touch of it. Like, so, I mean, and whenever you've registered a trademark, once you have that certification that it is a registered trademark and you have a registration number from the U.S. Patent and Trademark Office, you have a presumptive ability to enforce your rights due to U.S. registration. But keep in mind, if you don't have a registered trademark, I mean, but you do have a trademark that's in use, just from a common law standpoint, what we mean by that is you've just been using a trademark and actually you have a right to it technically without having registered it. I mean, you can still enforce those rights. The only problem is you're not going to be able to, the only problem with enforcing those rights is you're not going to be able to claim damages. That you've been damaged in some way by somebody else's use of it, unless the damage from their use has been relatively egregious and they've made a lot of money basically just straight up infringing on your trademark rights. So the bottom line, assets such as trademarks have value to potential acquirers and investors. It's one of the things investors do look for. I mean, I would say patents are probably more important to investors. They want to know that you've got a patent pending on certain things. But that said, a trademark, if it's a trademark heavy business, is important as well. It is something that can be acquired, and it is something that has what we call book value in goodwill, which has, I mean, quite frankly, I mean, an intangible value that we assign to it on the balance sheet, which increases the overall value of your company. So do we have any questions about that? Awesome. So I mean, to give you an example of protectable trademarks, so Apple, Google, Netflix, Coca-Cola, those are all examples of protectable trademarks. But let's talk about some of the differences here. So let's talk about Google and Netflix versus Apple. So Apple is a normal word, right? It's a dictionary word. I mean, it existed well before Apple became a company. It was around, it's been around for whenever people started using Apple in the English language. So hundreds, potentially thousands of years, right? As far as Google goes, Google was never a word to begin with before. I mean, it was something that was just created by the people who started Google, right? And I mean, many businesses are like that, Netflix being one of them. I mean, that word did not exist. I mean, it's not in the dictionary. It is just a company name. It is extremely unique. And so a word like that, I mean, while not technically a dictionary word, can technically be a trademarkable word. So whenever we're trademarking stuff, I mean, we're sometimes looking at this from a bifurcated standpoint. On the one hand, we're looking at your ability to trademark the plain name of your business. So for instance, I could potentially go get a trademark for JonesKertz. There are certain rules related to trademarking actual names. I'll talk about that here in a minute. But I mean, generally when it comes to like trademarking, I mean, the business name, a lot of businesses actually do have the ability to do that. As far as your, as far as trademarking stuff like Apple, it's a little bit more difficult. You have to make sure that the class you are claiming for Apple is technically, I mean, the appropriate and that nobody else is using it in that particular class for that particular purpose. That said, you also basically have to disclaim right to use, I mean, the general dictionary definition term Apple, like because you're not allowed to just take something that is colloquially used. I mean, that is just basically out there in the ether. So for instance, I mean, you might have heard a story about LeBron trying to trademark Taco Tuesday, right? Well, I mean, his application to trademark Taco Tuesday was rightfully denied, only because it's just out there in the ether. Practically every place that sells tacos runs a Taco Tuesday event. Practically every place that sells tacos, I mean, uses the phrase Taco Tuesday because it's so commonly used. I mean, it's lost trademarkable value, really. And Yeah. And so Coca-Cola is another common example. I mean, these are, by the way, these examples, I'm using these just to give you a broader idea of, I mean, some of the larger ones that can be trademarkable. I'll talk about some smaller trademarks that we've handled here in a little bit. But yeah, so symbols and drawings. So not every brand has to have a name underneath it. I mean, for instance, we go back to the Apple symbol. So that's obviously trademarkable. That denotes a certain set of products and a certain set of products, the same as does, I mean, the Puma brand. I mean, most people identify with that. I would argue that Puma is actually not as significant as Apple, only because Puma's symbol, in my opinion, is very close to the symbol that is on older Jaguar cars. If you've ever seen the hood emblem, it actually looks pretty similar. As far as a name logo combination, so Amazon, Red Bull, and I want to talk about Red Bull. Red Bull's an interesting case. So practically all of the value of the company for Red Bull is in its trademark. As a matter of fact, apparently, if you come anywhere near it, they will threaten to sue you or actually sue you for damages, which is, I mean, the part of the reason why we as lawyers practice trademark law is to help prevent, I mean, instances where you might even accidentally just step on someone's toes and infringe their trademark. But especially, it is a good idea to do a little research beforehand and make sure that if you are using a similar name, that it's not going to draw the ire of the people who have that name. Red Bull pays a lot of money to lawyers as well as to online algorithms and online services to enforce its trademark rights. And those algorithms are designed to detect anything that is remotely close to the name Red Bull so that they can flag it and evaluate whether or not they are going to enforce their rights against the person who has filed an application for a trademark. Red Bull is, I mean, when I say it's all the value, think about the sponsorships. They're pretty much in every major action sport on the planet, all across the globe. And so they really are looking, like, whenever they're enforcing this brand, they're enforcing it for that reason. It has sponsorship value. People buy Red Bull not really because it's a great drink. As a matter of fact, it tastes rather vile if you've ever had it. I mean, I believe that most people tolerate the taste of Red Bull. That said, I still drink it sometimes only because, you know, it's got brand value, and to be honest with you, it's a good energy drink. But yeah, Red Bull's interesting. I don't believe very many people, like Amazon, has to enforce its trademark rights against very many people, though I can imagine that some people may be using the brand on, say, storefronts in an illicit manner. That said, sometimes people who assist people with creating brands also assist them with some of the trademark stuff. So back when I was in college, I mean, some of the groups I was a part of would often make T-shirts. Well, actually, the people who would make those T-shirts would have to make sure that they weren't infringing on the trademark of a particular brand. And for the most part, they were creating a derivative version of a brand, or incorporating some previous version of a brand into the brand that we were attempting to create. And so it was like some of the people who create or design logos, graphics, things like that, will assist you with sort of not interfering with other people's trademarks. But yeah, here's some other examples. Slogans, just do it. What are other types of slogans that we frequently see? Honestly, I'm drawing a blanket at the moment, but the truth is, like, slogans are technically trademarkable. Oh, actually, this is a good example. I just read about this the other day. Jeff Foxworthy trademarked "You Might Be a Redneck." You might remember Jeff Foxworthy as the redneck king of basically the 2000s. He was all over. He was all over Comedy Central with his group and Larry the Cable Guy and Ron White and all those other people. So, I mean, he trademarked "You Might Be a Redneck." At first, apparently, the USPTO is going to say, no, that's not trademarkable. But apparently the case was overturned, and Jeff Foxworthy was actually allowed to trademark the phrase "You might be a redneck." It was technically a slogan for him. Right? I mean, it's not a slogan necessarily in the sense that "just do it" is a slogan where they're putting it right above the Nike symbol. But I mean, it is something that he actually put on T-shirts. It's something that he put on merchandise and sold. He made a lot of money off of it. Trade dress. So trade dress is interesting. Not very many companies are going to be allowed to get a trademark for trade dress because I'll tell you, the United States economy has actually moved closer and closer to a system of to a service-based economy. We are not producing as many hard products as we used to. Most of our products are being produced overseas. And I'll tell you, I mean, as far as the uniqueness goes, not a whole lot of people identify. I mean, well, actually, I'll walk that back a little bit. Some people identify the products they buy by the packaging themselves. So the shape of a Jack Daniel's bottle technically possesses its own trademark, right? And I mean, most people who have ever been in a liquor store can probably tell you that they could identify that just by the feel of the bottle itself. I mean, you pick it up, it feels a certain way. Not all bottles are that way. I mean, as a matter of fact, for one reason or another, some people don't do, unique bottles, mainly because it just increases the cost of the product itself, right? I mean, that said, Jack Daniel's probably has its own manufacturing facility for this sort of thing, so the cost of doing that is really minimized for them. Whereas if you're having stuff manufactured overseas and it's custom products, that could be more expensive and eats into your margins. Trade dress, though, can include other things like, for example, the AirPods case. So yeah, I think I actually have one on me. The AirPods case itself technically possesses a trademark. So it's so unique, as a matter of fact, it's egg shaped, that the federal government has decided that it will actually enforce Apple's rights to the shape of this and the design of it. As a matter of fact, you might have seen in the news that there was a competitor of the Apple AirPods that was importing goods, and they were seized by U.S. customs agents. And the reason they were seized is because the shipment supposedly infringed on Apple's trademark for this trade dress. They technically have a design trademark for this. So pretty interesting stuff. That's not going to typically be the case. And actually, if you're talking about whether that was right or wrong, in my opinion, the U.S. government should not be seizing goods for that reason, unless the goods are 100% counterfeit, and that is the basis for an infringement claim. I mean, counterfeiting goods is a common thing. The instance with the seizure where, the government seized the Apple AirPods lookalikes, those were actually unique products unto themselves that were being imported and had been manufactured and designed by a company that was based here in the US. They were not intentionally counterfeiting those goods. They were actually taking them to market, and I believe they're still trying to get them back. And so pretty interesting stuff. The government probably shouldn't be doing that, because it shouldn't be playing referee with that. You should be able to import those goods so long as they're not counterfeit or intentionally counterfeit, or regardless of whether they might infringe. And then just leave it up to the companies to figure it out on their own whether or not that's actually the case. So one of the common questions, a lot of people think it's almost instantaneous to get a trademark. That's simply not true. The question we often get is, how long does it usually take? It's about 12 months. I would say, your best guess, budget 18. It's not like you need it overnight. Anyway, you're able to use the trademark itself and you're able to use the brand itself while the application for your trademark is in process. And so we are not necessarily worried about the amount of time it takes. The amount of time it takes, by the way, has nothing to do with, the inability for companies or law firms like ours to move quickly. As a matter of fact, filing a trademark takes very little time at all. It takes very little time, especially for plain name trademarks. Logo trademarks are a little more complex. They take a little more time to assess and make sure that we're getting it right. And the process, I'll tell you, it takes about 4 or 5 months to get a response from the US Patent and Trademark Office. The reason it takes that long, they've got a backlog of thousands at any given time. And the attorneys are putting together basically office action letters. And those office action letters have a process unto themselves. And this process, by the way, is not the sort of thing where I get to call up the US trademark office's attorneys and get to hash it out with them. This is all done by written letters. And we have a certain amount of days to respond to office actions before the application is no longer in good standing. You have to continue prosecuting it. When we say prosecuting, that's not the bad form of prosecution. This definition of prosecution is really, the idea of just moving something along. You have to keep moving it through the process, or eventually it will become abandoned and you'll receive a notice of abandonment. You can revive an abandoned trademark application by by paying certain fees and basically, restarting the whole process. But you generally, unless we think that, the trademark is for sure going to be infringing on something, or somebody comes out of the woodwork and says, hey, we own a trademark, we own that trademark, technically stop using it, then, we're usually not going to abandon the trademark itself, unless you tell us to do so. So, as far as trademark examination goes, so they do an examination, and then and by that we mean they examine your basis for obtaining the trademark. They look at common names, they look at common symbols, and they also look at the classes you are registering it for use and see if there are any other interfering marks, basically. Then it goes into eventually it goes into publication, where, it is entered into the US Patent and Trademarks Office's trademark publication, which, I believe every weekday they come out with a new publication, and they're lawyers who they spend their mornings checking it. I technically don't do that, mainly because, it's just not a good use of my time. It's far easier for me to do a trademark search, and basically do an online search to figure out whether or not somebody else is using your name or potentially even your logo. But yeah, and then eventually it becomes officially registered and you receive the certificate. What laws apply to U.S. trademarks? So the Lanham Act governs trademarks and gives the USPTO authority to regulate trademark application and registration. So it's delegated. Congress has technically delegated this authority to do all of this to the U.S. Patent and Trademark Office under certain regulations, and the Trademark Office is semi-autonomous. The USPTO is allowed to make its own decisions. They even have their own tribunals. So there's a trademark appeal board, technically, where, if you believe that you've been wrongfully denied a trademark, you can appeal and go through the process. In some cases, sort of oppositions will be brought before the TTAB, which is the appeal board. So, you might be there with a third party eventually at some point. That said, it's when we start this process, we don't we try to do our best, but we don't really ever know if you are going to experience some sort of interference with a trademark, right? We do our best to make sure that you're not running into any potential issues. And really, sometimes we will be on the phone with a client and they will say, I want this trademark. And then while I have them on the phone, I do a quick search on TESS, which is the search engine for trademarks for the USPTO. And almost immediately, I'll tell you, I mean, I would say about 50% of the time, I see something similar. But we look at the classes and we assess, is this in the exact same class? Are these people using it for the exact same purpose? Is there potential for real confusion there? Is it distinctive enough to where we could argue, no, these people have a different trademark. Ours is different. It's not going to interfere with theirs. Also, our website is totally different. So there's really no chance that they would ever, that it would ever interfere. And I mean, there are certain ways in which we can coexist with potentially interfering trademarks. I'll get to that in a little bit, but yeah, it has to be, the trademark has to be used in commerce where Congress can regulate goods. So the idea is interstate commerce. So you may have heard that you can obtain a trademark at the state level, right? So in the state of Texas, you can obtain a Texas trademark. Typically, that trademark application costs, similar fees to what a USPTO trademark costs. But I'll tell you, what you really want is federal registration. You don't really ever want a trademark that's just local. But sometimes we do get local trademarks, and the reason we do that has to do with regional importance. So to give you an idea, we had a client that had a regional name. It used the name Texas, and then it was followed up by another just regular name. But the name itself, the two words were alliterative. They both started with T, and about every 6 months, somebody was popping up using the name. It was extremely inconvenient. To give you an idea, I had to send multiple letters to different individuals telling them to stop using the name. In one case, we actually discovered that somebody had an LLC that was using the exact name. And I had to send them pretty threatening letters to say, stop using this name. To give you an idea, this business has been around for 6 years using this name. We really need you to stop, only because it's causing confusion. People are going to think you are us, and we don't want that. And that really was the case. It was literally their trademark followed with the letters LLC. And the person thought that they had superior right to the trademark because they had filed for an LLC first. Unfortunately, I had to inform them that that wasn't the case. And that really isn't the case. Whenever you're, it was a matter of, we had used it first, in commerce in the state of Texas. It had not been used anywhere else though in commerce. So the federal trademark thing, was safe to say, sort of off the table. I didn't think we were necessarily going to be able to use it. But I thought maybe it would make it would be a good idea for us to get a Texas trademark for that company. Right. But yeah, it also needs to be distinctive. It can't be a generic term or merely descriptive. So, for instance, we call ourselves JonesKertz, and the Jones and Kertz does not have a space in between it. Now, let's say we called ourselves the law office of Kyle Kertz and Matt Jones. Well, that's pretty generic, and it's really just descriptive. It's not a brand the same way JonesKertz is a brand. It's not associated with startups that way. You're just calling yourself the law office. It's literally just a description. So as far as different types of applications goes, there are really two major types though. On the previous page, I'll get into this here in a minute. So there's an intent to use application. So let's say we haven't yet used the brand or the name itself in commerce. So when we say use in commerce, sometimes it is as simple as you getting a landing page for your website set up. And if you go ahead and get that done, we can pretty much skip the intent to use phase, because the intent to use is just you notifying the government that, hey, I'm about to use this trademark. And there are people, I mean, the ITU application technically has a useful, importance, and it's technically we would do an ITU if we were worried that other people would come after the trademark, or if we just want to see if this will draw out some people who might have some of those paid services or algorithms set up to detect whether or not this trademark is going to be used. So this can be used for when we don't want to go the full distance right away. We just want to investigate, right? That said, I know a lot of other lawyers that actually, I mean, whenever it comes to trademarks, their process for doing this is to just file an intent to use and then update the filing to a use in commerce application and provide what is called the specimen for the brand or the plain name. So, and by specimen, I mean, we're talking you have to show literally a printout, a PDF, a JPEG, where you can demonstrate that it's been used in that the logo, the plain name has been used in commerce. To give you an example, that company I was talking about was in education. They print their stuff on folders and give them out to kids, right? Like, so I actually had the customer send us a photo of the folder itself, and because that's on goods, right? I mean, if they were selling that as merchandise, we could technically file it for a merchandise class. But I mean, technically, we were just getting the education class of service for their brand. So as far as this goes, yeah, it has to have already been used in commerce. That is a prerequisite for all of this. You simply apply to register the trademark under one or more goods or class services. So Madrid Protocol. So if you have a US trademark, I mean, technically there are treaties with other countries. There's basically a pact under the Madrid Protocol. An owner of a trademark application or registration in a home country where that country is a part of the Madrid Protocol, I mean, you can seek protection in other countries that are parties to the treaty, including the US. It includes pretty much all of Europe, Asia, and South America. That said, China, I mean, if you're registering a trademark, good luck. I mean, China does a pretty awful job of enforcing American trademarks. So I would say your better bet, I mean, it's going to be in Europe and South America. I mean, most likely Europe, especially the UK. But it's important to register or maintain trademarks in foreign jurisdictions, basically due to the differences in foreign trademark registration if you're going to offer products and services in international markets. So one of the key differences, I mean, keep in mind, we don't practice international law. I mean, but we do allow for, I mean, and help people obtain international registration of trademarks under the Madrid Protocol as a part of registering a trademark if you need that. So let's say, for instance, you're starting a skincare company. The skincare company is going to sell products in a bunch of different countries, right? Well, it would make sense then for us to have a trademark registered in each of those countries. But I mean, you have to keep in mind, other countries do not have the same rules as the US. So under common law rules in the US, we can sit there and say, you know, I was using this before you, and even though I didn't register this trademark, I can go after somebody that's in the US using a similar trademark that began using it after I started using mine, and say, stop using it. You're infringing. And in some cases, we can sue that person for it and obtain damages. And once that person knows they're infringing, if they continue to use the mark, we can prosecute that a little bit further and basically take them to court and say, hey, they sold products and made money off of our name after they knew that they were infringing. Pretty important stuff. So but I mean, here's one of the headlines from a while ago. Netflix secured Space Force trademark before U.S. Armed Forces. So, and here's the tagline: snag trademark rights in Europe, Australia, Mexico, and elsewhere. They didn't do it in the U.S. That said, the U.S. does not. The U.S. does obtain trademarks. Surprisingly enough, I thought this was a cool fact. The United States government obtains trademarks for its military agencies and controls those trademarks. That said, it does not register those trademarks in foreign countries for obvious reasons. Military trademarks in foreign countries, we're not technically occupying foreign countries in that way. And so, I mean, for one reason or another, the U.S. government does not actually do that. But Netflix had a show that starred Steve Carell called Space Force, and so they registered the Space Force trademark literally everywhere else. Kind of interesting. It doesn't really mean a whole lot. I mean, it's not like they screwed the U.S. Armed Forces out of the trademark itself. It just means that the Netflix has the right to use that trademark going forward. By the way, if the federal government ever stops using the Space Force trademark for whatever reason, in other words, they simply abandon the idea of the Space Force, well, I mean, technically Netflix could probably come in and reclaim that trademark. I was actually watching Shark Tank the other day. By the way, as far as content goes, like for venture capital deals, Shark Tank is a retail startup focused like venture capital show. Basically, they require that the businesses already be in business, basically. But to give you an idea, there was a company there that had revived a trademark for a product that was common in the 80s, and they literally, like, the patents on the products had actually expired. So I mean, they were just fair game. They basically restarted a company that had been shut down by its original owners and took adverse possession of the trademark because it was no longer in use. I thought that was pretty cool. It's not very common that we would sit there and say we should definitely adversely possess a trademark, but some days we do actually assess that. I actually have a current client right now that we are there's a trademark currently active for the name that they are using, but we can pretty much tell that the owner of that company has abandoned the use of the trademark. As a matter of fact, everything online suggests that they are no longer using it, and that actually, if you look at the entity that would own it or control it, they no longer own or control it. It appears because they're no longer in business. And so we've actually reached out to the guy who would own it, because the company is shut down and technically it would be his asset now. He will not get back to us. And so our argument with the government, the federal government, is this trademark these people no longer own this trademark, and this guy no longer owns it because he's no longer using it in commerce. It has been functionally abandoned. And that's our argument. Whether that stands up, we're still waiting to see. But we're also competing for that trademark with another company that's arguing the same thing, but we use the trademark. Our client used the trademark first, so we're going to win. What info is required for trademark applications? It's fairly standard info. I mean, they actually have a streamlined application for this. So, I mean, really, it's just name, address, email address, type of legal entity, and citizenship. You can get a trademark as an individual, but for the most part, you're going to have a company. Like 9.9 out of 10 people, I would say, are going to have a company, and they're not registering a trademark in their individual name. So you're going to have a drawing of the trademark, or it's just going to be a plain name. You're going to have particular goods or services and specific classes for registration, and you're going to pay the fees for each of those classes. And then proof of use in commerce, data first use in anywhere, data first use in commerce, and then specimen of use. The specimen is just a photograph or just a PDF showing that you're using it. We technically don't need much else in order to get that. But if you are getting individual classes, especially goods classes, we basically have to show the particular good that it was used on. So, I mean, in one case, for instance, we ended up, we were registering a trademark. The website didn't technically have the trademark yet because it was still in development. This guy ended up putting a wrap on his truck that included the logo. We told him, take a photo of the truck with the wrap on it. He sends us a photo of the truck with the wrap on it. We file the application, and he gets a trademark 12 months later, basically. So, and then payment of applicable fees. So also, yeah, you make a verified statement. It's basically you're signing just an affidavit, which is a statement of fact under penalty of perjury that you're not intentionally infringing or conflicting with the use of another trademark. That said, by the way, the person who filed their application, that person I was talking about, where we're claiming that this previous company is no longer using a trademark, and that another company, and that we're sort of competing with another company that is attempting to claim what we're claiming. Our argument to the USPTO is literally these people technically did make a false statement to the government claiming that they were not infringing, because they could have easily done an online search and found our customers or our client's website, which used the name in commerce. It's clear to us that it's clear to us that their registration or attempted registration of the trademark is hostile and that they're intentionally infringing. So typical fees. I mean, this was previous stuff. Obviously, I just showed you the new fees. So I'll send these slides out at the end of the presentation, but this is what it used to be. So I'll go ahead and skip that. I mean, to give you an idea, by the way, as far as fees go, whenever you're paying a lawyer or paying a service to do this, really, I mean, most lawyers are going to say, here is what our fee is, and then that comes with one goods or class service. And then they'll say, if you want any additional stuff, we can do that. It's just going to cost you whatever the time is plus the additional classes. And those fees will be just passed through to you at cost. So once I apply, what happens next? You get assigned a USPTO examining attorney. Like I said, we don't really have any contact with that person aside from sending letters back and forth. We'll get a letter in the mail, or just receive notice of it via email or something like that. The people will check for completeness of the application. So if it's not complete and you waited 4 or 5 months after not completing the application totally, you're gonna have to wait another pretty long amount of time. I mean, once you start sending office action letters and they tell you to finish your application, they'll check for the eligibility and basically put together whether or not they think it's eligible. And actually, they take a pretty clinical approach to this. It's not wishy-washy, in my opinion. I mean, they base the office action letters, especially if they're refusing registration outright to you, they're going to sit there and say, you technically can't register this, and here's the case law explaining why. It's just too descriptive. It's not distinctive enough. Also, here are some other ones that clearly infringe upon it. And here's what they could turn up on in an online search, basically. So likelihood that registration of trademark likely to cause confusion. This is what I was talking about before. The main goal of a trademark is to prevent confusion among products, services, classes of goods, right? And so if you are sitting there, creating a confusing trademark, we may advise you, to change it. And the USPTO may very well do that. And it's not a bad thing. I think a lot of people, they fall madly in love with the name of their company, or the combination name and logo, or just the logo itself. Whenever you're registering a trademark, I think you need to be relatively open to changing whatever name you're using or whatever logo you're using, especially if you use one of those online logo generators. Those are good and they work to a certain extent, but they're not exactly checking the USPTO symbol registry or brand or brand registry to see, is this infringing on a trademark? And by the way, if they're using a logo generator, the logos are going to be similar to other people's logos every now and then. And so, I mean, it's just going to spit something out that, and a lot of other people are going to be using very similar stuff. Our logo, to give you an idea, I used a logo generator system. I paid $50 for our logo, and we own it. I mean, that said, the symbol out to the left of it, in my opinion, is probably not capable of trademark registration, only because there are probably so many other people who have it, as well as, if you look at it closely enough, it's actually fairly similar to the Chase Bank logo. I mean, in a way. And so, I mean, if it ever came down to it, the USPTO would probably cite that and just deny our logo and make us change it. So you should check pending apps every 3 or 4 months. Really, it's like every 4 or 5 months. Initial it's every 3 or 4 months. It takes about 4 or 5 months after you've initially registered or attempted to register, and filed the application, and then it's every 3 or 4 months thereafter. Once you have office action letters and you're going back and forth with the USPTO. 3 to 6 months is how long the initial response can take. And by the way, I mean, we're not sitting here clicking refresh on the USPTO's website. I literally just set a calendar reminder 120 days out to check it, to see if it's been updated. And that's how we do this. It's basically, we just put it into a docket and then we just keep it moving until it's done. So next steps, either USPTO office actions, like I said, and then notice of publication. So what is an office action? So an office action typically outlines the USPTO attorney's objections to a trademark application, citing certain law. So applicants must respond in a timely manner. There are deadlines. And this is why oftentimes we want the lawyer, you might want a lawyer involved with this, because we know what the deadlines are. I mean, we're operating constantly pretty much on a 30, 60, 90 rolling day basis for our entire business anyway. And so, I mean, we're good at managing that. For other people, I mean, it's common that, normal person will file for a trademark and just forget about it. I've never really, to be honest with you, I've seen quite a lot of individuals try to file a trademark and they're just not successful at it because, we have access to case law. We have access to other resources. Also, we're trained to argue with other people who are attorneys. And so whenever we sit down to respond to an office action, it's just a matter of telling the USPTO's attorneys why they're wrong. Right. And it's not hostile or anything. We're just saying, hey, we get what you're saying, but here's why that's not the case, or here's why it should be registered. So make technical corrections to application or correct defects in proposed trademark, and then provide arguments in response to objections, explaining why substantive law refusals should be overturned. And then the next step, after an office action response, if you ever do have an office action, not every trademark application requires an office action. It just goes into publication. And then once it's been publicized for a certain period of time, if there are no objections from other people, then you receive a certification. So if the app passes the examining attorney's review, USPTO publishes a trademark in the official gazette for 30 days. Anyone can view the official gazette, like I said. And this is what I was talking about before the publication. I know people who check this every single day. I can imagine that's pretty boring. It's also not essential unless this is literally the bulk of what you do for a living. We have a pretty high success rate, by the way. I would argue about 80% of all the trademarks we apply for end up getting approved in the end. For our clients. And so, we have a pretty low denial and refusal rate. And that's not as common with other law firms. Other law firms, they tend to have about a 50% refusal or denial rate or office action rate. And so, I mean, I think we tend to do a pretty good job. So interested parties can file opposition to proposed mark within 30 days after publication. Possible one-time extension. Interested parties can file good cause extensions though total amount of extension time can only be 180 days. And then oppositions are resolved by either defending and counterclaiming or potentially resolving the opposition by agreement. And so I want to talk about this for a second, just to give you an idea of what your options are. So we file an opposition. If filing an opposition is different than filing a cease and desist letter, than sending a cease and desist letter. So if I see somebody using our client's trademark, we're going to send them a cease and desist letter. And we're going to basically tell them, hey, stop that. And the reason we're doing that is because we have to. If you don't do that and you don't enforce your rights, you could lose your trademark rights. And so, and there is a statutory period, I believe it's 2 or 3 years. If you don't enforce your trademark rights within a certain period of time after you have discovered that somebody is using a trademark that infringes on yours, you're going to lose your right to enforce it. I mean, that's literally the law. So, I mean, it's not essential that you are continually checking, but if you believe your trademark is worthy of continual enforcement, you may pay one of those third-party services to make sure that people aren't registering similar trademarks and that you're sending automated cease and desist letters basically to say, hey, stop that. But in the event it has been publicized, we can register opposition, which actually goes before the USPTO. And then it goes into a process where we're basically litigating the issue. Hey, these people are using it. We can prove that we used it first. And then it's basically a determination by the attorney, overseeing that opposition. So it's, I would say you definitely need to, it's not something that all companies need to be worried about if you're getting a trademark done. Just one of those things that, I mean, you need to keep in mind if you do think you have so much brand equity that you need to enforce those rights on a continual basis. So once the trademark goes through publication, what happens next? Certification. You get certified, you get a registration number, it's mailed to you. You can frame it if you want, but usually we just scan it. Like the must properly use mark to avoid abandonment. If you misuse the trademark, and by that I mean you alter the use of the trademark and you abandon it for that good or class, that good or services class, you have to amend or obtain another trademark for that good or class, that good or services class. So, I mean, you cannot just switch the use up. Like if you're pivoting your business without checking to see if the trademark would still be valid, right? So file continued use and renewal applications. So you can file a declaration of continued use around year 5 and year 9 after registration, then every 10 years thereafter. Declaration of incontestability after trademark is in continuous use for at least 5 years. Basically, that means that your business, your name, your brand has obtained secondary meaning. What does that mean? It means nobody else can really use that. They are presumptively damaging you, basically, if it and no one else can challenge ownership, or challenge you on mere descriptiveness, because and by the way, some people can challenge your trademark and say that it's merely descriptive, even if you do have a registered trademark. I mean, it depends. I mean, technically, a lot of people think as we get a trademark and it's done. That's technically not the case. To give you an example, certain major businesses, really large businesses, have lost their trademarks. To give you an idea, aspirin is probably the most commonly cited example. At one point, aspirin was a registered trademark, but at some point it gained so much critical mass as far as the market goes that literally every painkiller on the market was basically billed as aspirin. if you were manufacturing acetaminophen, everybody just called it aspirin. And so eventually they ended up losing their trademark in court, and the government said, hey, sorry about it, but I mean, that's the problem with being popular, right? So as far as, by the way, that's about the end of our presentation today. Do we have any other questions, Alex? I can't really tell if we do. Let me see. Nope. So yeah, to give you an idea, as far as trademarking goes, I mean, keep in mind, December is the last month where you're going to be able to file under the old fee schedule. And so just keep in mind that, I mean, if it's time for you to go ahead and do this, if you've been on the fence about it, just go ahead and pull the trigger. It's really not that expensive to get a trademark set up. I mean, and to be honest with you, like if you are interested in selling your business eventually, you get to put that on the balance sheet. You get to list it as an asset. I mean, whenever you're selling your company 3 to 5 years down the road, or whenever you decide to sell it. And I mean, it becomes one of those things that, hey, I mean, it has that intangible value that will increase over time, right? So anyways, guys, thanks for attending and hope to see you next month. Take care.